Last week, we saw 58 US law firms issue a joint statement defending special purpose acquisition companies, or SPACs. This included well-known law firms such as Kirkland Ellis, White & Case, Weil Gotshal Manges, Baker & McKenzie, and Latham Watkins. This statement has been released in response to 2 lawsuits by US law professors which question the legality of SPACs. So in today's video, we will be looking at this statement and what it signifies for the SPAC market. First, let's pretty briefly recap what SPACs are. SPACs are companies with no commercial operations, which are set up with the sole purpose of raising capital through an IPO in order to acquire an existing target company. For this reason, they are also known as blank check companies. SPACs usually have the target acquisition company already in mind, but they can raise money through an IPO without a plan for a specific company. When that is the case, they deposit their investors' money in trust accounts that hold short-term securities from the US Treasury or the money markets in order to accumulate interest. These funds cannot be dispersed for any reason except to complete an acquisition. The interest ensures that the investors are compensated somewhat for participating in the venture, no matter what. If the SPAC has not completed the deal within 2 years, it liquidates and returns the money to its investors. SPACs have risen in popularity in recent years. They have the advantage of being a faster and cheaper way to list publicly than a traditional IPO. For instance, the SPAC IPO process takes 3 to 5 months, while a traditional IPO would take 9 to 12 months, and with less regulation. This attracts owners of smaller target companies who may want to be sold to the SPAC in order to enjoy the prestige of the listed status and the more forms of funding or liquidity that it brings. Selling to SPACs is also attractive because it usually adds up to 20% of the sale price than it would selling to private investors. So what are the lawsuits about? The lawsuits are brought about by 2 professors, former US Securities and Exchange Commissioner Robert Jackson of New York University and John Morley of Yale University. They claim that certain SPACs should be considered as investment companies and therefore be subject to the Investment Company Act of 1940. The companies subject to the 1940 Act are those whose primary purpose is to invest in securities. The crux of the lawsuit is that some SPACs gather interest from securities while they look for a suitable target acquisition company. It claims that if SPACs are involved in securities for a year or more, then they should be considered as investment companies and therefore be subject to the 1940 Act. This is a problem because companies subject to the 1940 Act have stringent reporting requirements and strict executive pay limitations. SPACs are meant to be an easy way to reach an IPO by eliminating the time and expense of the regulatory requirements of flotation. Subjecting them to the strict regulation of the 1940 Act instead therefore defeats the big advantage that they bring to the table. So what have law firms said in their statement? Law firms rarely issue joint statements, even informal ones. This demonstrates the threat that the lawsuits pose to the industry. In their statement, they said that SPACs are in the acquisition business, not the investment business. SPACs are not primarily engaged in the business of trading securities, they said, and therefore the Investment Company Act of 1940 did not apply to them. From the outset, one obvious reason for law firms jumping to defend their SPACs clients is money. Many of the firms which signed the statement earn lucrative fees off SPACs, and logically they want to protect their business. But there may be less bias in their defense than meets the eye. Law firms are a traditionally risk-averse area of professional services, and they would not make such a publicly damning statement lightly. Therefore, another reason why so many law firms feel comfortable to voice their opposition is that they firmly believe that the basis of the anti-SPAC lawsuits is incorrect. As Jocelyn Arel from Goodwin Procter said it, if this were even gray, you wouldn't have law firms mobilize this quickly. However, perhaps the most important reason law firms issue the public statement seems to be to reinforce the public's confidence in the legal soundness of SPACs. This can be seen from the effects of the lawsuit. Bill Ackman, the billionaire founder of the SPAC targeted by one of the lawsuits, Pershing Square Tontine Holdings, said that the mere existence of the litigation hurt his SPAC's chances of finding a target company. After the lawsuit was announced, he said that he would have to relaunch his $4 billion fund with a different structure. He commented that the lawsuit may have a chilling effect on the ability of other SPACs to consummate merger transactions and to engage in IPOs until the litigation is resolved. When the lawsuits hit, everyone's first thought was that they are no different from the other 400 SPACs in existence. Therefore, law firms sought to issue this public statement to reassure SPAC sponsors and potential acquisition targets that SPACs are in fact legally safe. But will it be enough to restore their confidence? Investors may not want to have their money engaged with an entity which may be deemed unlawful in the future. If the anti-SPAC lawsuits are successful, this could also threaten a $700 billion industry. Also, it is very likely to catch the attention of regulators internationally, putting the SPAC trend in other jurisdictions in jeopardy. So what do you think? Are law firms just trying to protect their livelihoods? Or are their rebuttals sound and the lawsuits fundamentally flawed? Let us know in your comments below. And don't forget to leave us a like and subscribe for more great content.